Good afternoon. This is Renee Norris at Urban Wealth Management, and welcome to the Smart Woman Savvy Money 2010 webinar series. 30 minutes on the clock, 20 minutes to teach, and 10 to talk. The Smart Woman Savvy Money is a platform offered through Urban Wealth Management designed to provide our listeners with the tools and resources they need to create the life they desire and deserve. Our calls are held the second Thursday of each month from 1 to 1:30 p.m. Pacific Time. Our next three webinars are listed here on our wall. As you can see, Financial Fitbit, since many of us on this call have probably made a New Year's resolution to get our finances straight, we figure this is a good time to check in and see how that's going for you. So Urban Wealth Management's own Diane Manuel will lead that call. Next, we'll have our tech diva back, Zenobia. She's going to be back to share ways to make our digital lives easier by minimizing the need to have all those cords and cables. And she always has some great information to share with us. So I'm really looking forward to that because I don't know about you, but I am so tired of carrying around cables and cords and not knowing which one fits with which device. In October, protection specialist Erica Gaffari will share ways to cover your greatest asset. And it might not be the greatest, it might not be the asset that you think it is. So we're going to cover that. But you can also visit our website for upcoming events. Not all of them are listed here. We just got word that we will have Laurie Brucker, who is one of LA's top stylists, otherwise known as Laurie B., and she's going to be back with us for the November webinar with ways to freshen up your wardrobe for the holiday season. But for a schedule of our events and medias, please visit our website here for all events. And be sure to check out our blog as well. We've got great content here that we like to share with everyone. So our latest one is, Are You a Henry? That means high income earner, but not rich yet. So if you are on that track, you are on your way. But before we get started on today's talk, I'd like to cover just a few housekeeping items. Our call today is being recorded, and it's going to be available for replay for all who registered. Now, we realize we're on the West Coast. We have a lot of people that are calling in from all over the country. So the good news is that you can get this replay link and listen to it at your leisure and continue to listen to it. And feel free to share it with other people as well. Also, if you have any questions or comments, please use the chat box to enter your questions or comments. We'd like to try to stay on time as much as possible. That's why we call this the 2010 series, 30 minutes. So we'll talk, our speaker will speak for about 20 minutes, 20 to 25 minutes, and then we will leave those last few minutes for questions. We'll try as best as possible to stay on time, but for those who want to continue the conversation, please feel free to reach out to me for additional information and ideas. We are always looking for ways and topics to share with our community. So we get a lot of ideas from you, and we'd like for you to let us know what you want to hear about most. We will be dark in December, and we will pick up in January. So please get to our website and check on what we have coming up in terms of the upcoming events and topics. We generally will plan out a good 6 months in advance, so we want to make sure that you get it on your calendar and be able to make sure that you are available for that call as well. So I'm going to get started now by introducing our guest speaker today, Kimberly Davidson. And Kimberly is actually the founding partner of the Collaborative Center of Southern California, which is located actually right down the street from me in Hermosa Beach. Kim is a pioneer in the South Bay family law community for her work in no court options for divorce. In 2000, she chose to stop taking litigated family matters, and her practice since then has focused exclusively on mediation or collaborative practice as a way for couples to divorce. having been through a divorce myself, I can tell you that it may start out as being very civil, let's say, but there always tends to be some kind of anxiety, some issues that are a little bit more difficult to handle than others. And so really being in a space and an environment with someone who understands the process and you have legal representation that can help you with that is really, really key. Kim has extensive mediation and collaborative training and was a co-founder in 2000 of A Better Divorce, one of the first collaborative practice groups in Southern California. She then went on to assist in the creation of the statewide collaborative organization, Collaborative Practice California, and served as its second president. She's active in mentoring and presenting workshops in mediation and collaborative practice throughout California. I will also add that she's very knowledgeable. We do know that we have individuals on the call who are not in California, so she's going to be able to share some ideas about and resources for those individuals who are contemplating this platform or know of someone who is getting ready to go through a dissolution of their marriage, because it is a great alternative. And with that, I will introduce you to Kimberly. Kimberly?
Hi, Renee. Thanks so much for inviting me to speak today. When someone first hears their partner say these words, I want a divorce, there's undeniable panic. What will I do? Where will I live? How will I survive? What happens to the kids? Next to the death of a loved one, I think this is one of the most stressful experiences a person may ever go through in their lifetime. In our time here today, I want to share with all of our callers a new way to go through this experience, or a newer way, with built-in support and looking toward keeping your dignity intact and maintaining positive relationships into the future. First, I think it's helpful, though, to kind of share an overview of the steps necessary in California to obtain a divorce. And this would be regardless of process. And I know you mentioned if there are other listeners on the phone who are not in California, there are probably somewhat similar steps, although the timing and some of the things involved are different. So in California, the steps to obtain a divorce are actually pretty easy as far as the steps. And I like to say they revolve around three groups of paperwork. At some point, often one of the first things someone will do is they'll file a petition and a summons. And this essentially gives you a case number in which to file your final agreement under with the court, so you have a court order. It also starts the waiting period in California, which in the state of California is a 6-month cooling off period from the time the respondent actually receives the petition. I'll mention it is what I call a two-pronged test, meaning that if you file the petition, you serve it on the respondent, and 6 months passes, you get to the 6-month mark, you will not automatically be divorced, because you also need to have a written agreement, stipulated judgment that's filed with the court. But as I said, the serving of the petition starts that 6-month clock. Once that's done, you really don't have to worry about it. The clock is sort of ticking, if you will. The second group of paperwork, or the second step, I like to say, is for each person of the couple has to prepare and exchange disclosure. The purpose of this is so that each person fully discloses all the assets and debts that they're aware of and income. So there's both a document that's called a Schedule of Assets and Debts, which is an inventory of everything that exists either in joint names or with your name and someone else, a child, a parent, etc. And there's also an income and expense declaration. The exchange of these two documents then gives the opportunity for the other person to investigate more if they need to request statements, backup. In more traditional litigation, we call this discovery. And this disclosure is signed under penalty of perjury, and so it is something that the state, I guess, of California takes very seriously. Finally, the final step is to draft and sign a stipulated judgment. It's called a stipulated if it's voluntarily agreed to by the parties as opposed to a judge ordering it at trial. When you're in a cooperative process, which we're going to discuss today, meaning collaborative or mediation, you send it into the court after the couple has signed it, and the court basically rubber stamps it. They don't read it. They don't try to undo the agreement. They assume that if you've had the opportunity to have advice of counsel and you have willingly gone into this agreement, they're not going to undo it. What's included in this final judgment is essentially three things if you have children under the age of 18. It's going to dispose of all the property, so that would be everything that's listed on the schedule of assets and debts that I mentioned under the disclosure. Again, if you have children under age 18, there will be a custody and parenting plan. And finally, support, child support and spousal support. So those, again, are just the steps so that people have kind of a framework. So then if you are deciding to go through a divorce or you are unwittingly, I suppose, pulled into that, then there are process options for divorce. The one that probably most people are most familiar with is what I call the traditional, more litigation-based model, where each party has their own attorney, and they kind of work through the process. If they need the court's assistance, they can file for a hearing. Again, things are different in different states, but essentially there's some access to the court system where you have some kind of a hearing, and the court then makes a decision based on their whatever the facts and circumstances they see fit. One of, I suppose, the advantages, because all of the processes I'm going to talk about today have advantages and disadvantages, and I like to at least say that traditional litigation, the advantage is that somebody does make a decision. So if you have two people or one person who is not able to participate in coming up with an agreement or making a decision, then there is a way to get your divorce done, and that is to have somebody else make the decision. The disadvantages, though, I think of that process are many. Loss of control, because you give up control. Somebody else makes the decision. It often turns into something very adversarial, which when I used to do litigation many, many years ago, I found that people would come into my office. I would have a client, and they would say, look, I just want to do what's fair, and I want to take care of my family, my husband, my wife, whatever. I want to make sure our kids are okay. And very quickly it would disintegrate into something extremely adversarial, mainly because of the way the litigation is, sort of the process itself is structured. All of that leads to a process that's also very, very costly. I often recount to people that in the days when I did do family law litigation and you would have a hearing on a particular day and you were told to show up at 8:30, and you had to be there at 8:30 pretty much for roll call, if you will, for your case. But you might sit there for the next 6 hours until you actually had time in front of the judge, and that entire time you're actually paying your attorney to sit there with you. So again, a very, very costly, I think, inefficient process for most people. Mediation, another process that I think is a good option for many people. Cooperative, meaning that you stay out of court. In mediation, you have a neutral mediator that works with the couple. In this model, I think it's really important that each person have their own advising attorney. So typically someone who's maybe not in the mediation sessions with the mediator and the parties, but someone they can consult with between sessions. The advantages of mediation, I think, are many. It is, as I mentioned, you don't have any court involvement. Therefore, it's private. You maintain control. Very solution-focused, much more affordable than a court-based system. So those are all positives, and people, again, can choose to use some of the default rules in the state, whether it's California or another state, meaning what would a court do with your facts and circumstances if you showed up in front of them and asked them to make the decision. You can follow those default rules, but you also have the ability in a cooperative process like mediation or collaborative, which I'll discuss next, to really come up with your own agreements that don't have to follow what the law might otherwise dictate. Now, mediation has a few, just to finish up on that real quickly, some of the downside is you need cooperation, and there's no hammer. There's nothing to push it along. Collaborative divorce, which is where I really want to spend more of our time today, is a process that I think has a lot of benefits, even over mediation in many ways. In collaborative divorce, it looks more like a traditional process where you have you each have your own attorney, but you sign a stipulation that's filed with the court that essentially disqualifies either of those attorneys from representing parties if they should decide to opt out of the collaborative process and want to go to court. So that's the real divider, or what makes collaborative different from a more traditional approach. Again, you have solution-focused, no court, maintaining control, private, many of the same things that mediation offers. But I think what you have is you have a stronger container. And especially when you have parties that have a more difficult time in working with a mediator, a lot of times in mediation there can be sort of an imbalance of power, and it's very difficult for a neutral mediator to sort of work that out with parties, and so they have difficulty staying in a mediation process. In collaborative, you pretty much do away with that because there is no neutral. You each have your own attorney, but we sit down together in a very solution-focused manner and try to work together. I often say pull together. In a traditional litigation, you tend to get more of a tug-of-war. In collaborative, we're sitting down and we're working together. The other thing that's really very unique in a collaborative approach and in a collaborative process is having a team approach. And the team approach is one that I think really benefits people. Divorce, yes, you need attorneys. It's a legal process. But as those of us, Renee, myself, who've been through a divorce can attest to, the legal piece is just a small part of it. So much of it really revolves around the emotions and the financial aspects of that. And so in collaborative, we developed the idea, or it was developed over many years, of having other professionals to help the lawyers and to help the parties, the couple and their family in this process. So you have two attorneys, as I've already mentioned, and then to handle many of the emotional and communication issues, the idea of having coaches, again, not serving in the capacity of a therapist, but actually a coach through the divorce process. So time limited, one to work with husband, one to work with wife, or in other two husbands, two wives, whatever the combination might be. But there are a coach for each person to help them work through those issues that often can create real havoc in getting to a settlement. When there are children involved, having a neutral person, usually a psychologist, a mental health professional, who is trained to work with parents and create a parenting plan for their children. And last but not least, a financial assistance, a financial planner whose role is often more forward-looking in helping people to determine what might be the consequences of different settlement approaches they might look at taking. And sometimes a CPA who works in family law matters, which is more, I say, backward-looking, different from a financial planner, and that you sometimes need to look at more of a valuation of a business, cash flow if someone happens to be self-employed, or maybe tracing issues, even of community and separate property. So those would be the roles of the financial might assist in the process. So again, very much a team approach, and certainly from the standpoint of cost, a much more efficient way to go through a divorce. In traditional litigation, usually they don't avail of these other professionals typically, and so the attorney wears the hat of the both the financial person and also the mental health professional, and that they're usually not trained to do that very well, and their hourly rates are usually a lot more. So it's not very efficient to have an attorney try to wear all these hats. Much, much better for people to come into a process where we pull in the people that are needed to help them get through it. So that is the team approach. And then when we kind of look at sort of what are the guiding principles in a collaborative process, and I guess one of the things is that respect between both the attorneys and the attorneys working with the other party. So I always tell my client, this is not about me trying to, assassinate your spouse. This is not going to engender dignity, openness, fairness in this process. I want to be respectful of your spouse, just as the other attorney will be respectful of you. Very important, because that really encourages then compassion, understanding, and cooperation, which ultimately will help us get to a result that is typically much more favorable for both people involved and their family. The best candidates for a collaborative process, I would say, number one is someone who can listen to and give consideration to the needs of their partner, also, along with their own, but being able to understand. They don't have to agree, but understand what's important to their partner. And that sort of flows into being able to articulate for themselves what their interests and concerns are. I like to tell a story. I have many stories, but one of them has to do with the trade-offs that people can make in a collaborative process that a court would never be able to come up with or order. And that is for people to look at what's important to them and decide, is this something where we want to follow what the law would dictate, or can we come up with a better solution? So I had a couple once where they did not have children, but the two issues really revolved around an inheritance the husband received during marriage, and not knowing necessarily the rule that if he received it during marriage and kept it separate, that it remains a separate property. It's an exception in California to the community property rule. So he didn't know that or wasn't aware of it. Anyway, and he commingled it. He put it into an account with his wife's name on it. It was an investment account. I want to say it was maybe $200,000 or $300,000 that he'd received from his grandfather. So he assumed that was his separate property. And once wife spoke with her attorney and found out that no, in fact, he had commingled those funds, and now there was a presumption that they were community, and likely she was entitled to half of that, she indicated that she wanted that. Made him very, very upset. And the other thing that happened was that at the time, it was right after kind of the financial crisis in the 2008-9, I think it was, and he was in commercial real estate, and he had always made more than the wife. She had a salaried position. He always made more than her through the marriage. But he was sort of in a downturn just because of the financial situation in the real estate, kind of commercial real estate market. So for the first time, at the time they're divorcing, he's making considerably less than she is. So he then realizes that the law would allow him, it was a long-term marriage, he could receive spousal support from her. So then he raised that flag and made her very, very upset. But the law would have probably divided his retirement with her, given the facts and circumstances, and she would have had to pay him support. Not what either one of them really wanted, but because the other was reaching for something they felt was unfair, that was their sort of way to kind of strike back. So we basically came up with something where he agreed to waive any spousal support from her in exchange for being able to keep his retirement account. Another quick story was a collaborative case I finished this past year where the parties had 2 children together, but wife had a child from a prior marriage that husband in this marriage had essentially raised and thought of as his own, even though she had, a natural father and had somewhat of a relationship with him. And so stepfather in this relationship had not adopted her and couldn't adopt her because she had a father who would not give up his parental rights. But nonetheless, he felt very close to her and wanted to continue to have a relationship with her. By the way, I think she was 16 at the time, and they had a very close relationship, which was great. And he wanted to have visitation, time with her. Mom wasn't necessarily opposed to that, but she was really concerned about how she was going to make it now that they were in two separate homes, and so finances were very important to her. Dad said, or her husband said, not a problem. I'm happy to pay child support for a child that I wouldn't have an obligation to pay support for. No court would make him pay support for a child that was not his, and likewise, they would not give him any visitation rights. But these two were able to work that out, and I thought that was really a wonderful outcome for everyone involved. Finally, carrying through with candidates who are good for this process would be people who, as I just mentioned in the story I just shared, who can prioritize the needs of their children, who can communicate with each other, behave ethically, and essentially are willing to work creatively and look at options and work with a team of experienced professionals in coming up with something that they both feel good about as far as a process. And most of the time they see no benefit in the court process, and they understand how much more expensive this would often be at the end of the day and doesn't give them what they really want. So, looking at our time and realizing we're just about out of it, I'll just quickly mention as Renee has put this slide up, that this is a really good slide to sort of look at the differences between a collaborative and a litigation process. As I've shared, one you're in control, the other the judge controls. Cost, much more manageable in a collaborative process and predictable, and really very unpredictable in litigation. Timetable, you create it. As I said, for some people that can be a disadvantage, but I think for most people, once they understand how a collaborative process works, they can work through, and they really like the fact that they can create their own timetable. Privacy, huge. In a collaborative or mediation process, details can be kept very private. In litigation, your sort of dirty laundry is out there for everyone to see. So at the end of the day, I'm probably somewhat biased because, as Renee mentioned, I stopped litigating in 2000, and my entire practice is devoted to collaborative and litigation means of helping people go through the divorce process. But I think, again, there are many, many advantages, and I have worked with hundreds and hundreds of families through the years that I think ended up with a much better result than they would have had in a more traditional process. So with that, I'd like to turn it over and see if anyone has any questions.
Great, Kimberly. I do have a couple of questions. Here on this last slide, we have a number of resources that Kimberly has provided us with, and these are websites. Some of these are actually her own practices, so I will show that to you in a minute. The one here towards the bottom of here, the collaborative practice, since I indicated to her that there would be individuals not in California, this particular site, as you can see, is a good resource for both national and international platforms, and so it will give you a good overview as to what the collaborative practice is. And in some instances, there are actual means of filtering and finding local professionals in your area as well, so that can make it a little bit easier. This is actually, this particular website is one that Kimberly is a member of, and again, it speaks to this whole process of the collaborative team, and everyone on here works together with her clients, whether it's for the social work, the emotional side, the financial side, the CPA, and these are all part of the team. So this is one center that she co-founded in addition to running her own individual practice as a collaborative attorney and mediator. So I do want to thank you, Kimberly, because it was great information. So a couple of questions for you, and then we will probably probably need to close up. And again, I will ask the audience, if you do have any other questions, please use your chat box. The questions will come over to me, and I'll be able to ask Kimberly. So, Kimberly, question number one, if you agree to the collaboration process, what's your recourse if it doesn't work out? Can you go back to court, and does that usually happen?
Occasionally it does. Not very often. I would say that they've done sort of collected statistics from collaborative practitioners throughout the United States and, frankly, internationally, and probably about, it's a pretty high percentage, probably 85 to 90% of people who actually sign up to do a collaborative process are able, collaborative divorce concluded that way. For couples who can't and choose to transition out, they can absolutely do that. You are never giving up your rights in collaborative to go and have a judge make a decision. So if you feel like it just isn't working, it's not moving along, oftentimes what happens is, as I mentioned, is sometimes one of the people who goes into the collaborative process is not maybe able or willing to sort of move forward, and because you're in a cooperative process and there is no hammer, if the other party says, this just isn't getting done, I can't wait, this has been going on, we try to work with whatever resources we can, our mental health professionals, et cetera, try to move it along. But if we can't and someone transitions out, they can do that and move forward and then go into a more traditional system. But as I mentioned, both attorneys and any of the team members that work do not follow them into that more traditional litigation process as a way of kind of preserving the confidentiality of the settlement process.
Interesting. So they have to find their own attorneys at that point if they decide that this is not working for them.
Right. And we transition. We help them to sort of find new, what I call litigation counsel moving forward. But yes, the onus is on both parties, so they're equally yoked, if you will. And it helps to, as people are in the process, if someone says, I don't know that this is working, it's like, well, we've invested time and money. Let's see if we can't can't we keep. So there's an investment that I think both people feel once they have decided to sign up for this process, which I think is a good thing. And we try very hard to make sure that everyone understands sort of what's at stake here so that they can make an informed decision.
Okay, great. One last question then. You mentioned that the cost of going this route tends to be considerably less than it would be in a litigation process, which I can understand because that's an hourly rate. But since you are working with a collaborative team, are you hiring the whole team, or you contract with each one of the team members individually?
Right. And so oftentimes you might be working with the financial planner running through different models. So maybe you've come up with your collaborative attorneys and you've looked at a couple different options of how can we divide a property, does someone keep a house, et cetera, what might that look like? And at that point we might then pull in or have the couple meet with the financial planner and have them run some models. So the attorneys might not necessarily be at that meeting. So what you're doing is you're really having different people, but in an integrated way, do what they do best to help the couple. I tell people very much like in a medical model where I have a now a grown daughter, but she was diagnosed as a diabetic when she was young. And when we went in, she had both her doctor, but she also had a nutritionist. There was a psychologist and a nurse, and they were part of the initial team to help her sort of get through the initial sort of how do I deal with having type 1 diabetes and learning how to manage this in my life. And it was such an efficient process, and you see that a lot in the medical world. And this is drawing on that so that you're really paying for individuals as you need them, but you're not double counting, if that makes sense.
Mm-hmm. Okay, great. Fantastic, Kimberly. Thank you so much for your time today and sharing this whole area that I'm sure a lot of our listeners, certainly I wasn't aware of, and the differences really between the collaborative process, the mediation process, and the traditional litigation. So with that said, I do want to thank everyone for their time today. Look forward to having you on our call next month, where we will track your finances to see how well you have done relative to what your New Year's resolutions were with Diane Manuel and the Financial Fitbit. So with that, everyone have a great weekend, and look forward to talking with you again and seeing you, sort of, kind of, next month. Bye-bye.
Bye-bye.